plea to a drunk driving?
Yes, sir.
Oh my gosh. Is your problem some clothes on before you come back in here? No, you know something? I'm not gonna accept the deal. So were you on the sidewalk, driving on the sidewalk?
Never was I ever driving on the sidewalk.
All right, I'm not gonna accept the deal.
Your Honor, can we have a breakout room?
I guess I didn't mean what I said.
So you lied to me?
No, that's not what no.
Look, Your Honor, he was just...
Wait a minute.
And here's where the cracks start showing. He literally just told the judge he wasn't impaired at .197 BAC, then tries to wiggle out of it by saying he didn't mean what he said. Think about that when the stakes are this high. Every word counts. In court, once something is on the record, you can't just backpedal and say, "Oh, I didn't mean it." That's not how it works. Judges view honesty as the most valuable currency, and this guy just declared bankruptcy.
What?
Do you think was he confused, or was this a straight-up lie?
Plea to a drunk driver?
Yes, sir.
Oh my gosh. Is your problem some clothes on before you come back in here? Get your client together, Mr. Ogletree. Now let's go back on the record with Mr. Green. Mr. Green, you indicated you wanted to take the deal. Any objection for having attorney Edward Taylor stand in for your attorney of record, Mr. Ogletree?
No.
State your name, please.
Shamar Green.
All right, Mr. Green, turn your camera on. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand you have an absolute right to a trial?
Yes.
Mr. Taylor went over your other advice or rights in the breakout room, did he not?
Yes.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know by taking this deal, you're going to give those rights up?
Yes.
Has anyone offered you anything other than what's been stated in the record?
No.
All right, let me draw your attention back to January 1st, 2024, around 5:52 p.m., city of Detroit, in the area of Kentfield Street, 19015. Did you have an occasion on that day to come in car with the Detroit Police Department?
Yes.
Were you operating a motor vehicle?
Yes.
Did you have some alcohol before or prior to the operation of that motor vehicle?
Yes.
During or prior to the operation of that motor vehicle?
Yes.
What kind of alcohol did you have, sir?
I had just took a shot of, I think it was Bacardi.
And then how much? How much?
I had literally just took a shot with my dad.
So you took one shot of Bacardi?
And yeah, that's it. That was...
I'm not satisfied, Counselor.
Mr. Green, one shot would not have your breathalyzer that high. Did you have anything else to go with that?
I had something before I took that shot, some wine. That's about it.
Okay.
Well, what is this? What is this, sir? Did you have, I asked you how much you had to drink.
I had wine before that.
How much wine did you have?
I don't remember.
Will you stipulate to the forensic breath alcohol analytical report of a 0.197?
Yes.
Here's where things get downright ridiculous. His blood alcohol content, 197. To put that into perspective, that's over double the legal limit and the equivalent of about 10 standard drinks. And yet, he's standing there claiming he only had one shot. Do the math. One shot does not equal 0.197. This isn't just stretching the truth, it's obliterating it. At that point, it stops being a misunderstanding and starts being a deliberate dodge. So tell me, viewers, when someone lies this blatantly, should the judge go easier because they're young or harder because they clearly don't get it?
Yes.
Or a 0.197 191. You'll stipulate to that on your client's behalf?
So stipulated, Your Honor.
Did this alcohol impair your ability, does alcohol affect your ability to properly operate this vehicle, sir?
No.
Yes. Mr. Green, in order to take this plea, you have to state that you were impaired at the time
Yes.
that you got.
No, you know something. I'm not gonna accept the deal. You're sitting here telling the court that you're at a .197, and it didn't have any effect on you operating this vehicle.
Yes, I'm sorry.
No, you said no.
Your Honor, he probably was confused, Your Honor, because he didn't even remember how much he drank. That's how.
This is the moment Judge Perkins loses patience. Who can blame him? Imagine someone telling you, with a straight face, that being 2 times over the legal limit had no impact on their driving. That's not just arrogant, that's dangerous. Judges don't like games, and they especially don't like defendants trying to rewrite reality in their courtroom. When he denies impairment, he's basically saying, the law doesn't apply to me. That's the type of attitude that pushes judges to strip away deals and crank up sentences.
Intoxicated he was, Your Honor.
Unless he's so drunk that he doesn't even know that this is, well, let me see what happened, why he got stopped. So were you on the sidewalk, driving on the sidewalk?
Never was I ever driving on the sidewalk.
All right, I'm not going to accept the deal.
Your Honor, can we have a breakout room?
It says that he, on the PBT was taken, and this is the investigator's report, and it was at that time the PBT registered a .208. You may need some. I'm gonna order a substance abuse evaluation as well. You know, put you in a breakout room and speak with him again. Rejoin the room. We'll pass the matter. First line of the report says they called him driving on the sidewalk. I don't know what that means. I'm gonna get the officer in here to give me some explanation if you want to take the deal. Join the room, please. Mr. Ogletree, when you were out, are you there now?
I'm here, Your Honor.
All right, so here's the deal with your client. He indicates to the court that first and foremost, he started off saying that he only had 1 shot of Bacardi with his father. And he's got a .19 level of intoxication. So unless that shot was the whole half a pint or more, then that's not believable. Then he changes and in fact, I guess his memory was refreshed for some reason, and he says I had some wine too, and I don't know how much wine I had. So we go ahead and start on with the plea. In the police report, it says he's driving on the sidewalk. He said absolutely he's not driving on the sidewalk. And then I asked him, did this affect his ability to drive? He said absolutely not. So I think this matter needs to be set back. I'll give you an opportunity to respond to all that and have the officer come in and let's see what that officer, well, the officer in the report is saying a lot different than what he's saying. So what do you have to say about that?
Notice what's happening. Here his own attorney is left scrambling to explain the mess. Once a defendant starts contradicting themselves, the defense's job gets nearly impossible. The prosecutor doesn't even need to press that hard because the defendant is already handing over inconsistencies on a silver platter. And here's the thing, plea deals are built on trust. If a judge thinks you can't even be honest while taking the deal, why would they believe you're ready to reform? This is where defendants dig their own graves not with the crime, but with the cover-up.
Yeah, I did speak to sister counsel earlier when I appeared the first time, and she was saying she wouldn't have objection to a no contest.
Excuse me, for the record, you know what? For the record, Attorney Ogletree, you went and got a deviation from my supervisor. That was not my offer.
No, okay. So I just want to be clear on the record. In terms, I did request deviation, as I told the court the first time. but we did speak, and I asked, would you be okay with a no contest? So I don't know if you're saying you're not okay with a no contest now.
As I informed you, I'd leave that to the discretion of the court. No, if the court wants to take a no contest, I have no problem.
Well, and the thing is that I just feel that Mr. Green is not being totally upfront with the court.
That's it. The deal is dead. And honestly, this is why courtroom observers shake their heads. Instead of owning up, he doubled down on the lie. Judges respect accountability more than excuses. Even when you've done something wrong, admitting it shows maturity. Denying obvious truth, that shows immaturity and a lack of remorse. And that's the difference between walking away with probation versus facing harder penalties. If you were the judge, would you have pulled the deal too? Or given him one last chance?
That's what I feel he's doing. And not unless he's so intoxicated, which I can believe that at a point 19 that he just really didn't have. But I don't like it when it's time to just you're already making a deal and you've got the deal secured, and now it's time to put on the record what you actually did, and he goes totally off and just says, I only had one shot of Bacardi. So what is it, Mr. Green? Do you recall this night?
Yes.
Oh, and did I say, I asked him, did this alcohol affect his ability to drive? He said no.
Yeah, he informed me that he misspoke when he said that.
How is that? How'd you misspeak, Mr. Green?
Because I said the wrong thing, I guess. I didn't mean what I said.
So you lied to me?
No, that's not what no.
Look, Your Honor, he was just.
Wait a minute. This. How did it affect your ability to drive or not? Or
Yes.
Did you believe that it didn't affect your ability to drive?
No, that's not what I was saying.
Do you recall the incident?
Yes.
All right, I'm going to find him guilty as to the operating while intoxicated. I want a substance abuse evaluation. I need a phone number again from you. I know they probably already have it. I'm referring it to probation. You're going to submit to a pre-sentence investigation report and a substance abuse evaluation. What's the phone number again, please?
My number?
Yes. I do recognize that he has passed the test as far as his alcohol test, but I still, with the level of intoxication that he has, with his answers here today, I'm gonna order that test just and for his own benefit, for his age and everything. He's a young man, not even 25 years old or just 25 years old. I'm gonna order that. Sentencing date is going to be.
I didn't hear none of that. Your camera went out. It's disconnected, I guess. There we go. It just fixed.
All right, I'm going to order a substance abuse evaluation based on your age, the level of intoxication that night, and just your answers here today, and just for your own benefit. You're a young man. This is a serious offense, and I just want to see what they say as far as that. Let's set sentencing 45 days out. All right, and I'm going to dismiss the other matters with stipulation of probable cause.
We stipulate to probable cause.
All right, Mr. Green, I'm wishing you the best of luck. I'll see you back on July 23rd.
And
still retain your sobriety.
Do I continue to drop once a week with the same?
Absolutely. All the other conditions are still in place.
Okay.
And all right, if there's nothing further, sir, best of luck to you. And again, I don't have to tell you about coming in here laying down with no shirt on. You should be appropriately dressed for court. This is just like you being in the courtroom, even though you get the benefit of sitting at your, in the comforts of your own home, all right?
Yes, sir.
All right, if there's nothing further, have a very good day, and best of luck to you,
So
all
let's
right?
wrap this up here. We had a 25-year-old man caught drunk driving with a BAC of .197 who showed up to court shirtless and unprepared. Instead of taking a plea deal that could have minimized his punishment, he argued, lied, and contradicted himself, leaving Judge Perkins with no choice but to yank the deal and order a substance abuse evaluation. The takeaway? Courtrooms demand honesty, respect, and accountability. Without those, the system will make an example out of you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.